I'm here with John Eastman, former Dean of Chapman Law School and head of Chapman's Center for Constitutional Jurisprudence. We're here to talk about national popular vote. Now, the idea behind national popular vote is to get enough states with a combined total of at least 270 electoral votes, the minimum needed to elect the president, to cast them for the popular vote winner, regardless of which candidates actually carry those states. Now, I want to talk to Dr. Eastman about certain claims being made by NPV proponents, and then the general topic. But among the claims being made is that national popular vote is actually constitutional and that it doesn't do away with the Electoral College. As a leading constitutional scholar, Dr. Eastman, I'd like to get your opinion on these claims.
Sure. I would adjust your opening description there. Its purpose is not to allow the states to different manner. The purpose is to abolish the Electoral College and substitute in its stead a national plebiscite for president. It uses mechanisms that it thinks are authorized under the Constitution, but the end goal is to abolish the Electoral College, to abolish the founders' notion that we ought not to have a direct democracy election for president, but a diffused election that required the president to gain support from different regions of the country, different geographic interests, agriculture versus urban and rural. All of those things have to be appealed to in a electoral college system, and don't have to be appealed to in a national popular vote system. So their goal here is to abolish the Electoral College. And they do it by claiming that legislatures in the states have unfettered discretion to choose the manner in which they select their state's own electors. And the text of the Constitution doesn't include any limits on it. But we know for a fact that other provisions of the Constitution limit the exercise of that. So if a state legislature were to say, for example, that no one who's African American could be an elector, or no African American could vote for electors, that would violate the 15th Amendment, and it would be unconstitutional, even though that limit is not contained in the text of the state legislature choosing the manner provision itself. My contention is that there are structural provisions of the Constitution that equally check the authority of the state legislature. They can't use a state compact to delegate away their choice of electors to some body outside the state. And they can't do an end run on our constitutional amendment process to get rid of the Electoral College. And I think national popular vote does both of those.
Now, what would you say, proponents say, well, the Electoral College isn't mentioned in the Constitution. Even as they're saying they won't do away with it, they say almost that doesn't exist. How would you respond to that?
Well, that's patently false. The Electoral College is mentioned in Article 2, and it's mentioned in the 12th Amendment. Every state chooses the method within its state for choosing its presidential electors. Those electors are defined by the number of congressional districts plus 2 for the senators for each district. And this was an important part of the founding compromise to make sure that the big states didn't overshadow the small states. And it was one of the key conditions that allowed the small states to enter into this union. The other being the state selection of senators, not based on population. And those kind of non-population based parts of our system are critical to making sure we just don't have a raw democracy that can lead to a majority tyranny.
Now, did the Founding Fathers at the Constitutional Convention, did they explicitly reject the idea of a direct popular election of the president?
Yeah, there were several proposals discussed during the Constitutional Convention for direct election of the president, for population-based election of the president through the vehicle of the Congress. All of those were rejected in favor of the Electoral College system that, in their view, struck the best balance between population but also small state protection against a combination of large states that could tyrannize them.
Now, one criticism of national popular vote is that it constitutes a compact, interstate compact between the states, and that the Constitution requires the Congress to ratify any such compact. I wonder if you could expound on that a little more.
Yeah, Article 1, Section 10 allows states to enter into compacts, and they do all the time. Nevada and California have a compact on controlling pollution to the Lake Tahoe basin. New York and New Jersey have a compact about ownership of Ellis Island and the Statue of Liberty and the trade that goes through that. We have a multi-state compact on who gets the water from the Colorado River. So there are lots of state compacts. But states entering into a compact compact, it was recognized, could infringe on the rights of other states. And so there's this mechanism that those compacts are only valid if they're ratified by Congress. And that's very clear in Article 1, Section 10 of the Constitution.
What if you could address even the the equity issue, I suppose you might call it, of the national popular vote? Say, for example, in 2012, Barack Obama is reelected and NPV was in place, so that with enough states, you would have a situation where he would win the popular vote, presumably, and then Texas, which would not vote for him, would have to give its electoral votes to him. And what is could you address the fairness issue involved there if the citizens of a certain state vote to give their electoral votes to one candidate and then are having those votes given to the person they oppose because of the decisions of voters in the rest of the country?
Yeah, no, that's one of the key problems of national popular vote. And it's also based on a misunderstanding. The proponents of national popular vote claim that there have been 4 errors in our nation's history where the winner of the popular vote has not been elected president. Well, they're only errors if you assume that the popular vote is the sine qua non of choosing a president, a proposition that the founders explicitly rejected. You have to tap into the different regions, to the different states, small states as well as large states, urban areas as well as rural areas, in order to get elected president. That builds a broad ideological as well as geographic coalition that, in our view, is necessary for running a country as large as this. And it's proved to be spectacularly successful. The national popular vote would change that and establish just raw numbers as the sole criteria. That means that those states whose legislatures put them into this compact would then cast votes that would then be result in the opposite of what the voters of that state did. And that's where I think this violates the 15th Amendment, the 14th Amendment's protection of voting. It's very clear. State legislatures do not need to have a vote among the people of their states in order to choose electors. The legislature could do it itself. It could say that the governor is going to choose our electors. Any manner of somebody in state choosing the electors is permissible. But one thing that's very clear, that once you give the right to vote to people, it then becomes a fundamental right, and you can't deny or abrogate the consequences of that right to vote. That's exactly what national popular vote does. If I give the citizens of my state the right to vote on electors, and then I ignore their vote and I pick the votes of folks in Rhode Island and North Dakota, elsewhere, I have abrogated that right to vote, and that violates that fundamental right that was created for the citizens of my state. And let me give an even more absurd example, but I think it will show how troubling this national popular vote is, the way it would work. They claim that there's no limit on the delegation of the authority on who gets to choose my electors. Well, that can't be true. Suppose the legislature decided we're really keen on the Sultan of Brunei this year, so we're going to adopt as our method that the Sultan of Brunei gets to pick the electors from the state of Arkansas. Now, that's just preposterous. Well, what national popular vote doing is essentially the same thing, just a difference in degree instead of kind. We're going to say that no matter what the voters of Arkansas choose to do, we've handed over the decision to the voters of other states to determine who our electors from Arkansas are going to be. That delegation of that sovereign authority to somebody outside the state is where the problem with national popular vote exists.
One last question. I think this gets back to kind of the recent momentum NPV has acquired. The Republican Party presents itself and believes itself to be the party of the Constitution, of constitutional limited government. Yet you've had an alarming number of Republican legislators begin to sign on to NPV. What would you say to those 2 Republican legislators who are either supporting, considering supporting, or flirting with this idea?
Well, here in California, for example, I know one of the big arguments is there's a lot of money for national presidential campaigns raised in California, and because California has now become overwhelmingly Democrat, very little of that money is spent here in California. Not on advertising, more cynically, not on political consultants, and they think that national popular vote will force some of that money to get spent in California. I hope that that's not what's driving our legislators to support this thing, because it's a devastatingly bad idea. It will radically alter the nature of our constitutional system of government, and I think to the worse. And the other thing that we should be very careful of, think about the number of close elections that we've had in recent years. But the fight over those elections and hanging chads and claims of vote fraud have been limited to the particular jurisdiction where the real closeness occurred. If you have a close election on a national scale, the kind of things that we saw happen in Florida in 2000 or Ohio in 2008 will now be writ large in every single county, every single city, every single state in the country. It would be debilitating in our transfer of power from one presidential administration to another. The founders were unbelievably wise in this area, and we ought not to tinker with their mechanism.
Great. Thank you, Dr. Eastman. Appreciate your time. And this, again, is Dr. John Eastman. He's the director of the Center for Constitutional Jurisprudence here at Chapman Law School.
Thank you very much.